after 2004. He couldn't touch those. I did get those, which he got the other half. But I never told him he could have half. I told him he could have a fourth of them, was what I told him. That was our understanding. But he snuck all that in, you know.
Do you have the papers now that you signed?
Yes, I do. I don't have the originals. No, I don't have that.
You have a copy of
Yes, I do. I do. I do have a copy. And I got my attorney, I had to go, of course I had to go to Tyler and get Mr. Voberding, who's an appeal attorney.
I know Wes.
Do you know him?
Yeah, he's a good friend.
Well, and he didn't know that the judgment wasn't going to be rendered until January the 15th. They didn't render the final judgment until January the 15th. We thought it would be rendered within 30 days after. We thought that was the procedure that so we went ahead and filed an appeal, and then we had to ask to rescind that appeal. And so Mr. Voberding, in the letter to the appeals court, he asked that we asked for mediation, but he said, please, not in Wood County. Please do not have any mediation in Wood County, because that he knew by then that we weren't going to get a fair trial. We were not going to get even a consideration. That was the problem. There was no consideration. And I mean, there's two sides to everything, but there was only one side in this trial, and that was the plaintiff's side. And the thing about it that was so distressing to me, he doesn't even live here. He has a business in Mineola, but he doesn't live here. He lives in Lindale. And I've paid taxes here for 30-something years. And I didn't even get the benefit of paying taxes for all these many years. I didn't even get consideration from that standpoint. Well, he pays taxes in Lindale, Smith County. He bought a house over there. He's testified in court. He bought a house for $50,000, and now it's appraised at $168,000 because he bought it on the main drag there, and it's all gone commercial. So the house that he bought as a residential house is now commercial. So he's got it as commercial property.
So the value.
Yeah, so its value's gone up from $50,000. Now that's what he testified. He sold, but when we went to trial, the plaintiff's attorney had papers in limine. I don't know if you're familiar with that or not, but that means if you're going to a jury trial, you can ask to have so many things denied. Well, he had all this. When you have the judge is presiding, you don't have all that. But he said the plaintiff's attorney said he'd drawn all this papers in limine up for the fact that I'd had to give a deposition in 2006, and they made me give a deposition in 2006. And so he said he had drawn all that up, but that's not usually the case. And see, he had to charge. I had to pay for that. I paid for him to draw all that up. But the things that he denied that he asked in limine to be denied, and the judge denied the second contract being drawn up. He denied that. And he also, there was something else that he denied besides the contract being drawn up. But anyway, the second contract, it laid out that he was going to pay so much down, which was the exact amount of the attorney's fees, $13,000. That was what he was going to pay down on the property. But when he went to court and testified against me, everything was cash, and more cash. So they denied this contract being submitted, the second contract, whereas he was only going to pay $13,000 down. And that same $13,000 was what I got assessed in attorney's fees.
How about that?
That seemed to be exactly.
Yeah, they got
so he didn't pay anything down on the land then. He paid nothing down on the land.
Yeah, your money went to his.
My money went to his down payment. But he lied on the witness stand and said it was going to all be cash. And here was his second contract, which the judge had denied to be allowed to be drawn into the trial, that said he was going to pay $13,000 and finance the rest of it, which would have been $47,000 he was going to finance. So ironically, I wound up paying the $13,000 attorney's fees that would have been the down payment on the land. Because not many young people, which he was, at that time he was 28 years of age, he's now 31, not many young people have $60,000 in their pocket to pay down on property, do they? But he also had, when he had the land surveyed, 20 acres, he had two different surveys, 20 acres and 5 acres. Well, he was going to pay for the 5 acres, see, and finance the 20, use the 20 as, to finance the rest of his house, I guess his house,
Yeah.
or the rest of the property. That was what I was thinking.
Right.
Or else he did it for logging purposes, whatever. He might have done it for logging purposes
Has
too.
he logged the land at all?
Not yet. But I'm thinking that the reason he hasn't done it yet is because his attorney advised him to give a little period of grace there. Because I'm sure he's going to. I'm sure he's going to.
Yeah.
Yes.
But the attorney probably wants to protect him from getting
Uh-huh.
his tail beat,
Uh-huh.
you know, in case you come out on top of this deal.
I do want to sue him, but I have to find an attorney to sue him is the problem. Not many of them will come to Wood County. Not many of the lawyers in Tyler will come to Wood County. And Mr. Voberding, when he took my case, he said he had just lost a case in Wood County. Well, that was 2 cases right there in a row he lost in Wood County. Well, he knows, Mr. Voberding agreed with me that, you know, there is no justice in Wood County.
Well, and him coming to Wood County would probably, you know, since he's already lost a couple, he probably, you know, that would be the third curse.
Yes, yes.
He probably can't do business in Wood County.
That's right.
And win.
That's right. That's
just
what.
because of who he is.
That's right. Because the ex-sheriff's deputy that I talked to, he hates all this regime. He calls them the courthouse gang.
Yeah.
The courthouse gang, and he said, you know, that's why they can't get anybody to run against the judge, is because all of the young practicing attorneys know they will starve to death. If they go run against him in an election year, like today, he was up for election this year, and there was nobody to run against him, so he was automatically.
Yeah. Oh, yeah. So he needs to like
Yes.
a heart attack or something.
Yes,
Yeah.
yes. So it was very sad that they couldn't get anybody to. None of the young attorneys will run against him, but they're trying to make a living, and there's no way they could make a living running against him.
You're right.
But he was in business with the plaintiff's attorney. He was in business with him for I'm not sure how long, but it was they say it was very obvious that, you know, he could have recused himself,
Yeah, and should have.
but he should have
himself.
recused himself.
Right, exactly, because he was too well connected to the case.
Exactly. But it was very obvious from everybody in the courtroom that the attorney made all the decisions. The attorney told the judge what to do. The attorney, matter of fact, what got me, and I knew there was no point in having a trial. The judge turned around and said to the plaintiff's attorney, said, well, what's up next? You know where this is headed better than I do. Well, I knew right then and there I didn't have a chance.
Can you get the transcript from the trial?
I have the transcript.
You do have
I have the transcript. I do. That's how I know that the plaintiff committed perjury more than 50 times. Yes.
Interesting.
But I have to prove, but I can prove 3 times, and my friend that's an attorney says you only have to prove 1. But I cannot get the courthouse up there to even take any charges of perjury.